So before proceeding with the privacy of communications and correspondence, let's talk about administrative arrests first, because this was not mentioned in the earlier video. So arrests made as an incident to a deportation proceeding is an example of administrative arrest, and the power to deport aliens is an attribute of sovereignty and essential to self-preservation of every state. So not all arrests are criminal. There are also administrative arrests allowed by law, such as for deportation proceedings. The constitutional provision against unreasonable searches and seizures does not require judicial intervention in the execution of a final order of deportation issued in accordance with law. It contemplates an order of arrest in the exercise of judicial power as a step preliminary or incidental to prosecution or proceedings, or for a given offense or administrative action, not as a measure indispensable to carry out a valid decision by a competent official, such as a legal order of deportation issued by the Commissioner of Immigration in pursuance of a valid legislation. So in deportation cases, an arrest of an undesirable alien, i-deport, ibabalik sila sa country where they're from, ordered by the president or his duly authorized representatives in order to carry out a final decision of deportation is valid. It is valid, however, because of the recognized supremacy of the executive in matters involving foreign affairs. So what is exclusionary rule? All evidence obtained in violation of Section 2, Article 3 shall be inadmissible for any purpose in any proceeding, which we already discussed. This is the doctrine of the fruit of poisonous tree. It means whatever is obtained from something that is illegal or not valid. For example, there was an illegal search or illegal seizure, so the fruits of such illegal search and seizure cannot be used as evidence. Same with illegal arrests or invalid arrests. So once the primary source, which is the tree, is shown to have been unlawfully obtained, then any derivative evidence, which is the so-called fruit derived from it, is also inadmissible as evidence. So that's one of the effects of unreasonable searches and seizures. An unlawful search will result in the exclusion from admission as evidence of which was obtained from such unlawful search and seizure or arrest as the case may be. Further, an unlawful search and seizure may justify the use of self-help in the form of resistance to such unlawful search and seizure, the criminal prosecution of the searching officer, civil damages against such officer, and disciplinary action against the officer by his administrative officers. So now let's go to Section 3 of Article 3 of the 1987 Constitution, still in the Bill of Rights. Section 3 states that the privacy of communication and correspondence shall be inviolable except upon lawful order of the court or when public safety or order requires otherwise as prescribed by law. Any evidence obtained in violation of this or the preceding section shall be inadmissible for any purpose in any proceeding. Yung ibig sabihin ng preceding section is a Section 2, which is unreasonable searches and seizures and arrests. So private and public communications, the Constitution does not have a specific provision protecting the right to privacy. It is a penumbral right formed from the shadows created by several constitutional provisions. That is to say, the right of privacy is located within the zones created by various provisions of the Constitution and various statutes, which protects aspects of privacy. So in the case of Oplev versus Torres, the different provisions in the 1987 Constitution also constitute zones of privacy. That's the provision that I stated earlier, Section 3, Privacy of communication. Also Section 1, life, liberty, and property. Section 2, unreasonable searches and seizures. Section 6, liberty of abode. Section 8, right to form associations. And Section 17, right against self-incrimination. So, what are the three strands of the right to privacy? We have first, decisional privacy, second, informational privacy, and third, locational or situational privacy. When you say decisional privacy, liberty in the constitutional sense must mean more than freedom from unlawful governmental restraint. It must include privacy as well, if it is to be a repository of freedom. The right to be let alone is indeed the beginning of all freedom. The concept of liberty would be emasculated if it does not likewise compel respect for his personality as a unique individual whose claim to privacy and interference demands respect. Now, informational privacy is the right of an individual not to have private information about himself disclosed, and the right of an individual to live freely without surveillance and intrusion. Locational or situational privacy is privacy that is felt in the physical space, such as that which may be violated by trespass or unwarranted searches and seizures. So right of privacy, it is not a preferred right, thus there is no presumption of invalidity or encroachments of right to privacy, so you have to allege it. Freedom of correspondence and communication, because of the preferred character of the constitutional rights of the freedom of speech and of expression, there is a weighty presumption of invalidity, vitiates measures of prior restraint upon the exercise of such freedoms. When you say presumption, it's presumed yung weight of the burden of proving that there was a violation is kung sino yung may presumption. So there's always that presumption whenever in a case involving freedom of correspondence and communication, there is a presumption that it is violated. So it is upon the burden to prove otherwise is upon the government that such freedom of correspondence and communication was not violated. However, for right of privacy, it is not presumed. Therefore, the person alleging that his privacy was violated has the burden of proof to prove that his or her privacy was violated. So requisites of the existence of the right to privacy. The subjective requisite is that a person has exhibited an actual expectation of privacy. So you have to be entitled to privacy in the first place. And second, objective, the expectation be one that society is prepared to recognize as reasonable. So what are the forms of correspondence and communication covered? We have letters, messages, telephone calls, telegrams, and other analogous to the foregoing. This is the umbrella statement to cover all other forms of correspondence and communication. So intrusion is allowed, yes. But there are only certain instances wherein intrusion is allowed, intrusion to the privacy of a person. And encroachment on the right of privacy is invalid as a general rule when there is a reasonable expectation of privacy. So you have to look into the objective requisite of the existence of the right of privacy. So sa sitwasyon ba na yan, there's an expectation of privacy, or based on the circumstances, there's no expectation of privacy. Okay, and also have to balance it or compare it or weigh it against compelling state interest. So there's intrusion is not allowed if there's no reason or no expectation of privacy in the situation, or if a person has no right or no entitlement to the privacy, or there is a stronger, more compelling state interest, which is why the intrusion had to be done. So when is there a valid intrusion to someone's right to privacy? If there's lawful order of the court and when public safety or public order requires it. okay, as may be provided by law. So EO number 424, or Executive Order number 424, adopting a unified multi-purpose ID system for government does not violate the right of privacy because, first, it narrowly limits the data that can be collected, recorded, and released compared to existing ID systems, and provides safeguards to protect the confidentiality of the data collected. So the collection of data, as a general rule, is not allowed. Intrusion is not allowed because it's your personal data. You're entitled to it. Information, that's informational privacy, one of the strands of the right of privacy. However, what happened in EO number 424, why it did not intrude in the right of privacy? Because the compelling state interest is stronger. And that is what's the purpose of the multi-purpose ID system. Okay. For security of the people themselves. It's for their security. Because not having a unified ID system would make crimes easier to commit. Okay, so that's one. And in gathering the information, there is an undertaking on the part of the government that they will only collect necessary information for the purpose and that they will protect the information that they collect. So an intrusion into the privacy of workplaces is valid if it conforms to the standard of reasonableness. So for example, you're applying for a job. Of course, they have to get information from you. You can't expect to get a job without giving your information. You have to give your information because it has a purpose. So the information collected, it's not unreasonable. It's reasonable, given the circumstances. So under this standard, both inception and scope of intrusion must be reasonable. It is justified at inception if there are reasonable grounds for suspecting that it will turn up evidence that the employee is guilty of work-related misconduct, for example. Scope of intrusion is reasonable if measures used in the search are reasonably related to the search's objectives, if there's a search, and it is not highly intrusive. Right may be invoked against the wife who went to the clinic of her husband and there took documents consisting of private communications between her husband and his alleged paramour, because even if this is already a decided case, even if a man and a woman are already husband and wife, they are still entitled to their individual right to privacy. So of course, public figures cannot expect the same privacy as that of normal individuals. For example, politicians and celebrities. A limited intrusion into their privacy is permissible given that their job is to be under the scrutiny of the public eye. Basically, publicity is part of their job. So there's a limited intrusion to a person's privacy that is permissible if such person is considered as a public figure, and the information sought to be elicited from him or to be published about him constitute matters of a public character. The interest sought to be protected by the right to privacy is the right to be free from unwarranted publicity from the wrongful publicizing of private affairs. Of course, these celebrities, these politicians, these public figures, they also have private lives and they're entitled to privacy for their private activities, which are outside the realm of legitimate public concern. And it was held in a case that being a public figure does not automatically destroy in total a person's right to privacy. But the treatment is different, of course, because there is a permissible intrusion allowed, limited. They have less expectation of privacy given their chosen careers. So online privacy, it is first necessary that said user manifest the intention to keep certain posts private through the employment of measures to prevent access thereto or to limit its visibility. Therefore, for example, a Facebook user who opts to make use of a privacy tool to grant or deny access to his or her post or profile details should not be denied the informational privacy right, which necessarily accompanies said choice. But if such user of social media, for example, chooses to post something publicly, hindi naka-private, then there is no expectation of privacy with that. Hindi siya pwedeng magreklamo kasi naka-public eh. But if it is set to private, then there is an expectation of privacy that it is only shared to certain individuals that are quote-unquote, for example, friends or followers niya, limited to those people only. But of course, there's no expectation of there is lesser expectation of privacy when you post on social media, whether you have a private or a public profile, because you're putting it out there. So these cases, they're decided based on the circumstances. Exclusionary rule, any evidence obtained in violations of Section 2 or 3. Okay, Section 2, unreasonable searches and seizures and arrests. And Section 3, right to privacy, shall be inadmissible for any purpose in any proceeding. And this applies not only to testimonial evidence, but also to documentary and object evidence. The Anti-Wiretapping Act, RA number 4200, clearly and unequivocally makes it illegal for any person not authorized by all the parties to any private communication to secretly record such communications by means of a tape recorder. The law does not make any distinction. So, effect of violation, the communication shall not be admissible in evidence in any judicial, quasi-judicial, legislative, or administrative hearing or investigation. Generally, the provisions in the Bill of Rights are protections against the government, not individuals, because it's a civil case if it's against an individual. However, in the case of Zulueta versus CA, as mentioned earlier, that's the wife of the doctor, and the wife went through the documents in the clinic of her husband. So, in that case, the court has recognized an instance where it may also be applied as against private individual. So, used the Bill of Rights against an individual, not against the government. So, while Zulueta seems to be an exception to the state action requirement, Zulueta's state action requirement is that, invoking of the provisions of the Bill of Rights against the government, not individuals. Zulueta's application to the exclusionary rule has only been cited once to a state action. So that's it for privacy. For the right to privacy, Section 3. Okay, so next we will be discussing the privacy of communications and correspondence, which is Section 4 of the Bill of Rights.